Let's get straight to the point. Hiring a new employee in the United States comes with more costs than just their salary. A significant part of that extra cost comes from payroll taxes. Specifically, we are talking about FICA taxes, which fund Social Security and Medicare. Normally, both the employer and the employee contribute to these funds. The employee pays 6.2% for Social Security and 1.45% for Medicare from their paycheck. The employer matches this, paying another 6.2% and 1.45% on top of the employee's gross wage. When you add all that up, the employee's share and the employer's share, it totals 15.3% of the employee's earnings. This is a standard cost of doing business. Now here is where the story changes for certain international student graduates. A specific rule allows some of these graduates working under a program called Optional Practical Training to be exempt from paying FICA taxes. This exemption isn't just for the student, it extends to the employer as well. This means the employer does not have to pay their 7.65% share, and the employee does not have their 7.65% share deducted from their pay. The combined effect of both sides not paying is where the about 15% cheaper idea comes from. Use an infographic comparing standard hire, salary plus 7.65% employer tax, versus OPT hire, salary only, here. It is a powerful simplification, but it highlights a real financial difference that can influence hiring decisions. It is a long-standing provision in the U.S. tax code designed for non-resident aliens who are temporarily in the country for educational purposes. The logic is that since these individuals may not be staying to collect Social Security or Medicare benefits, they shouldn't be required to contribute to the system. For a company, especially a startup or a small business where every dollar counts, saving nearly 8% on the cost of a new hire can be a game changer. It can mean the difference between hiring one person or two, or investing that saved money back into research and development. To put this in real numbers, consider a recent graduate hired with a salary of $70,000 per year. For a standard U.S. worker, the employer would owe an additional $5,355 in FICA taxes, $70,000 times 7.65%. However, if that new hire is an F1 student on OPT, who qualifies as a non-resident alien for tax purposes, the employer owes nothing for FICA. That is $5,355 in direct savings for the company in that year. While the total 15% advantage includes the employee's portion, the employer's 7.65% saving is a direct and tangible benefit to the company's bottom line. This financial incentive is a key reason why OPT has become such a vital talent pipeline for American companies. So, what exactly is this OPT program? At its core, optional practical training is a period of temporary employment directly related to an international student's major area of study. The program is authorized by U.S. Citizenship and Immigration Services for students holding an F1 visa. Think of it as a practical, hands-on extension of their academic experience. It allows students who have earned a degree from a U.S. institution to gain up to 12 months of real-world work experience in their chosen field. University study, F1 visa, graduation 12-month OPT, optional 24-month STEM extension. It is a critical bridge that connects American higher education with the American workforce, benefiting both the student and the economy. This program isn't just some side benefit. It's a fundamental part of the value proposition for international students choosing to study in the United States. They come here for a world-class education, and OPT provides them with a chance to apply that knowledge in a professional setting before potentially returning to their home countries. For the U.S., it creates a system to retain, at least temporarily, the bright minds it has just spent years training. These are graduates from top American universities, equipped with fresh skills and a global perspective ready to contribute to innovation and growth from day one. For students in certain fields, specifically science, technology, engineering, and mathematics, recognizing the high demand for these skills in the U.S. economy, the government created the STEM OPT extension. This 3-year window gives employers a more substantial period to work with these talented individuals, making the investment in training and integrating them into the company far more worthwhile. It also gives the student a longer runway to prove their value and explore long-term career paths. It's important to understand that OPT is not a separate visa. The student remains on their F1 student visa throughout the entire period. The OPT is simply an authorization for employment that is granted as a benefit of that visa status. The work they do must be directly related to their field of study. An art history major cannot use OPT to work as a software engineer. A computer science graduate cannot use it to work as a chef. This requirement ensures that the program stays true to its purpose, providing practical training that complements a student's education, not just providing a general work permit. This is the law that created the financial bedrock for two of America's most important social programs, Social Security, Medicare. These taxes are the engine that funds retirement, disability, survivor, hospital insurance benefits for millions of Americans. FICA tax is not a single tax, but is composed of two separate parts. The first part is the Social Security tax, which is set at a rate of 6.2%. This tax is only applied up to an annual income limit, which changes almost every year to adjust for inflation. For 2025, let's say this cap is around $175,000. Earnings above this amount are not subject to the Social Security tax. The second part is the Medicare tax, set at a rate of 1.45%. There is no income cap for the Medicare tax. It applies to all earnings. Here is the crucial part. FICA is a shared responsibility. The employee pays their portion, and the employer pays a matching portion. The employee sees a 6.2% Social Security deduction and a 1.45% Medicare deduction coming out of their paycheck, total 7.65%. The employer must also pay 6.2% and 1.45% from its own funds for that same employee. Total FICA contribution for one employee, 15.3%. This is a fixed, non-negotiable cost of employment for nearly every worker. The system replenishes the Social Security and Medicare trust funds. When calculating fully burdened cost, employers add payroll tax to the gross salary, health insurance, retirement contributions, workers' compensation insurance. FICA is a significant and predictable expense for every hire. Now we connect the dots between OPT status and payroll taxes. The U.S. tax code makes a distinction between a resident alien, non-resident alien for tax purposes. This is not the same as one's immigration status. An individual can be legally present in the U.S., but still be considered a non-resident for tax filing. The key rule for students on F1 visas is that they are generally treated as non-resident aliens for the first 5 calendar years they are in the United States. F1, student, in U.S. 5 years, end up on. Yes, non-resident alien, FICA exempt. No, resident alien, must pay FICA. During the time they are classified as non-resident aliens, they are exempt from paying Social Security, Medicare, FICA taxes, on wages paid for services performed under their OPT authorization. This exemption is a powerful feature. When an OPT worker is exempt, it means the 7.65% that would normally be deducted from their paycheck simply isn't taken out. Their take-home pay is instantly higher than that of a U.S. citizen colleague earning the exact same gross salary. The entire 15.3% FICA obligation vanishes as long as they maintain their non-resident alien tax status. This is the genesis of the 15% advantage claim. It's the sum of the savings for the employee and the employer. It is critical to understand that this is a temporary condition tied to tax residency. The moment an F1 student crosses the threshold into becoming a resident alien for tax purposes, the FICA exemption disappears. This typically happens after the student has been present in the U.S. for some part of more than 5 calendar years. For example, a student who arrived in August 2020 would likely become a resident alien for tax purposes at the beginning of 2026. From that point forward, even if they are still on OPT, they must start paying FICA taxes, and their employer must start paying FICA taxes like any other U.S. worker. The clock is always ticking. This tax status rule creates a clear, albeit temporary, window of opportunity. For the duration of the exemption, the employer enjoys a significant reduction in labor costs. The employee enjoys higher net pay. This alignment of interests can make hiring an OPT graduate an incredibly attractive proposition. The company saves money, the new hire gets more cash in their pocket, helpful for a recent graduate dealing with student loans or the high costs of setting up a new life. For an employer, the FICA exemption is not an abstract concept. It translates directly into tangible bottom-line savings. Let's break down the math in a clear, practical way. Imagine a small tech startup planning to hire a junior software engineer. They have budgeted a salary of $80,000 per year for the position. If they hire a U.S. citizen or a permanent resident, their total cost would be $80,000 in salary plus $6,120 in employer-paid FICA taxes. That's 80,000 times 7.65%. The total cost to the company for this one role is $86,120. Now, let's say they hire a brilliant recent graduate from a local university who is on OPT and qualifies for the FICA exemption. The salary is the same, $80,000, but in this case, the employer's FICA contribution is zero. The total cost to the company is simply the $80,000 salary. That is an immediate first-year saving of $6,120. For a cash-strapped startup, that money could be used to buy new computers for the team, fund a marketing campaign, pay for a critical software subscription. It's real capital that can be redeployed to fuel growth, making the OPT hire a strategic financial decision, not just a talent one. The impact becomes even more pronounced when a company scales up its hiring. Consider a larger firm that decides to build a new data science team by hiring 5 recent graduates, each at a salary of $90,000 per year. If all 5 are standard U.S. hires, the company's annual FICA tax bill for this team alone would be $34,425. That's $90,000 times 5 hires, times 7.65%. If, however, they hire 5 qualified OPT graduates who are all FICA exempt, that entire $34,425 cost is eliminated for the duration of their exemption. This is a substantial sum that can significantly lower the barrier to building out new teams and taking on ambitious new projects. This financial advantage allows companies to be more competitive in the hunt for talent. It might enable them to offer a slightly higher base salary to attract the best candidates, or to invest more in benefits and perks that improve employee retention. Some companies might even see it as a way to, de-risk a junior hire. The lower initial cost makes it easier to take a chance on a promising but unproven graduate. Regardless of the strategy, the 7.65% savings on employer-side payroll taxes represents a significant and direct financial windfall that makes hiring from the international student pool an incredibly compelling business proposition. For the OPT student, the FICA exemption often feels like an immediate and welcome financial boost. Seeing a full 7.65% more in your paycheck, compared to your peers, can make a huge difference, especially when you are just starting your career. A graduate earning $60,000 a year will take home an extra $4,590 annually. That's nearly $400 more each month. This extra cash can help pay down student debt faster, cover the high cost of living in major U.S. cities, or simply provide a much-needed financial cushion. It's a tangible benefit that makes the transition from student life to professional life a little bit smoother. However, this advantage can be a double-edged sword. Social Security contributions. Medicare contributions both exist to build eligibility for future benefits. By not paying into the system, OPT workers are not accumulating credits toward future retirement benefits or disability benefits. For a student who plans to work in the U.S. for only a year or two before returning to their home country, this is largely irrelevant. They wouldn't be in the system long enough to qualify for benefits anyway, but for those who aspire to stay in the U.S. long-term and eventually become permanent residents or citizens, this period of non-contribution represents lost time in building their social safety net. Furthermore, there is a risk that the 15% advantage can distort salary negotiations. Unscrupulous employers might see the total 15.3% FICA savings employees portion, and use it as a reason to offer a lower base salary to an OPT candidate than to a U.S. worker for the same job. They might try to capture the entire savings for themselves. This is unethical and exploitative. OPT workers should focus negotiations on the market value of their skills and the role itself, not on their temporary tax status. The employer's FICA saving is a benefit to the company. It should not be used as leverage to underpay the worker. Ultimately, the OPT worker must be savvy and informed. They should understand that the FICA exemption is a temporary benefit with long-term implications. It provides a short-term cash flow advantage but offers no progress toward long-term U.S. social benefits. While the FICA exemption is a powerful tool, it is surrounded by a minefield of rules, exceptions, and potential pitfalls. The most important caveat is the rule of tax residency. The 5-year clock for F1 students is a general guideline, but the actual determination can be complex. The substantial presence test used by the IRS has specific day-counting rules that can be confusing. A mistake in determining tax residency can lead to serious problems, like needing to file amended tax returns, paying back taxes with interest and penalties, affecting both the employee and the employer. Assuming the exemption applies without verification is a risky gamble. Another critical limitation is the temporary nature of the OPT program itself. Standard OPT lasts only 12 months. The STEM extension can extend to 36 months, but it's still finite. Employers who rely on OPT talent must plan long-term. That usually means navigating the H-1B visa lottery system or other employment-based green card pathways. Legal fees and administrative burdens can dwarf any FICA savings. The legal and political landscape is constantly in flux. A future act of Congress or a change in IRS regulations could modify or eliminate the FICA exemption. Relying on it as a core long-term staffing strategy is unwise. Treat it as a temporary benefit, stay informed about proposed policy changes, and be ready to adapt. What is true today on November 2, 2025, may not be true in the future. Finally, compliance is non-negotiable. Hiring an OPT student brings specific responsibilities, especially on STEM extension. Employers must complete a formal training plan, attest the OPT student's employment will not displace a U.S. worker, and report employment changes to the student's university. Failure to comply can jeopardize the student's status and expose the company to penalties. FICA savings are attractive, but they don't absolve administrative and ethical duties. It's a perk that comes with added responsibility. For employers looking to leverage this opportunity, seek professional guidance right away. Don't navigate tax and immigration rules alone. Consult a payroll provider, consult an accountant, consult an immigration attorney who specializes in this area. They can verify a candidate's FICA exemption status. They can ensure your payroll system is set up correctly. They can keep you compliant with reporting requirements. This initial expert investment can save costly mistakes and legal headaches. It's the foundation of a responsible hiring strategy. Employers should practice fairness and transparency. Treat FICA savings as a company benefit, not a salary bargaining chip. Offer compensation commensurate with the role. Offer compensation commensurate with the candidate's skills. Offer compensation commensurate with market rate. Be transparent with the OPT hire about temporary tax status. Plan for long-term visa options well before OPT expiration. For OPT students, use your university's International Student Services Office. ISS advisors are experts on F1 rules. They can guide maintaining status. They can guide applying for OPT. They can explain reporting obligations. They can direct you to tax help resources. Make an appointment with your ISS advisor before job hunting. Keep meticulous records of your physical presence in the U.S. When interviewing or negotiating salary, lead with your value, not tax status. Focus on your skills. Focus on your education. Focus on what you can contribute. If FICA exemption comes up, acknowledge it as a potential benefit, then steer back to qualifications and proper salary. Remember, the exemption is temporary. Use OPT to gain experience. Use OPT to build your professional network. Use OPT to prove your worth. Prepare for what's next, sponsored visa, or a new opportunity elsewhere. In the end, the 15% advantage is more than just a catchy phrase. It points to a real, quantifiable financial difference rooted in the FICA tax exemption for certain OPT workers. For employers, this translates into a direct 7.65% reduction in payroll costs, a significant incentive that can make it easier to hire emerging talent and fuel business growth. For the OPT graduate, it means a higher take-home pay at a critical time in their early career. It's a rare win-win scenario. That has made the OPT program an essential pipeline for bringing highly skilled U.S.-educated graduates into the American workforce. However, this advantage is not a simple, permanent discount. It is a temporary benefit governed by a complex web of tax and immigration laws. The exemption is tied to the student's tax residency status, which inevitably changes over time. The OPT program itself is finite, requiring employers who wish to retain talent to plan for long-term visa sponsorship. And the entire system exists within a fluid political environment where rules can and do change. To navigate this landscape successfully requires diligence, foresight, and a commitment to compliance from both the employer and the employee. The path forward is clear. If you are an employer, embrace the opportunity to hire from this incredible talent pool, but do so responsibly. Verify eligibility. Consult with experts. Treat your employees fairly, regardless of their visa status. Think long-term from day one.